when clients come in, a common question I get asked right away is, how is child support calculated in New York State? So in the state, there is an act called the Child Support Standards Act. Under this act, the non-custodial parent has to pay the custodial parent child support. So first, what you have to figure out is who is the non-custodial parent, who is the custodial parent. That is figured out in one of probably three ways. There's either a custody order already in place that either gives one parent sole custody, so that parent would be the custodial parent, or it gives joint custody with primary residency to one parent, so the parent with primary residency would be the custodial parent. Or if there's a shared time arrangement between both parents and it's not dictated who has primary residency, then the court looks at who has the most overnights with the children, and the parent with the most overnights is then the custodial parent. In the rare cases where there's a 50-50 split down the middle, there's an exact equaled shared time with the kids, then the court looks at which parent makes the most money, and that parent would be deemed the non-custodial parent for child support purposes. So like I said, the non-custodial parent is the one that has to pay child support to the custodial parent. The Child Support Standards Act dictates that a percentage of the non-custodial parent's gross income should be given as child support. So, for example, for one child, it's 17% of the non-custodial parent's gross income. For two children, it's 25%, and so on. It goes up from there. What that means is that they take both parents' combined income. So say one parent makes $60,000, the other parent makes $40,000. Combined, those parents' income are $100,000. So under the Child Support Standards Act, they look at what each individual parent's income, what their percentage is of the total. So for the parent who makes $60,000, their income is 60% of the total income. For the parent that makes $40,000, their income is 40% of the total income. Those percentages are important because they can be used as the starting point of what each parent has to pay for mandatory add-ons. So those are things like unreimbursed healthcare costs, daycare costs, etc. So basically under the Child Support Standards Act, it gives not only the child support obligation, that the amount of money that the non-custodial parent has to pay, but also the percentage of extra things that each parent has to pay for. So if you have daycare, then under that example I gave, one parent would have to pay 60% of the daycare costs, the other parent would have to pay 40% of the daycare costs. And the answer is no. Generally, the Child Support Standards Act is a starting point for the support magistrate when they're deciding what the child support obligation should be. So there's, the Child Support Standards Act gives that starting point, but then the support magistrate has discretion to either deviate upwards or downwards from that number. There's a multitude of factors that the support magistrate looks at when deviating upwards or downwards. Factors that a support magistrate looks at to deviate downwards usually include how much time the children spend with the non-custodial parent. If they're spending 49% of their time with a non-custodial parent, that usually means that the non-custodial parent is probably spending more money than just the child support. They look at if there's any extra expenses that the non-custodial parent incurs due to visitation. If they live far away and it costs a couple $1,000s to come visit their children and they do that a couple times a year, then usually the support magistrate will deviate downwards from the Child Support Standards Act. And they also look at any other extra expenses that a non-custodial parent provides. These days, every child has a cell phone usually, no matter how old they are, and those are expensive. So if one parent is paying all the cell phone costs or all the health insurance costs, any extra costs that they're paying on a regular basis can be used to deviate downwards from the Child Support Standards Act figure. There are some factors that the court looks at that would warrant an upwards deviation. Usually it's if the non-custodial parent has little to no involvement in the child's life, then they usually deviate upwards from the Support Standards Act. We will write a petition for you if you're the one petitioning for child support, asking the court to open a matter for you and asking the court for a child support order. We have you come in, review it, notarize it, sign it, and we send it to the court. The court will then review it and open up a file, and they'll give you an initial appearance date. That date is where both parties come and meet the judge or the support magistrate for the first time. And prior to that date, they want you to fill out what's called a financial disclosure affidavit. So we help you out with that as well. A financial disclosure affidavit is probably an 8 to 9 page document, and it provides the court with kind of a snapshot of what your finances are. So you list your income, your monthly expenses, any creditors you have, anything extra that you're paying each month. And that way the court can, like I said, get a snapshot of what your finances are like. They also ask that you attach the previous year's W-2 and a recent pay stub so they can see what your salary was last year and if your paycheck is on point to be the same salary this year. So when the court gets all this, we provide this to the court ahead of time so that when you go in for the initial appearance, the court will give you, they'll advise each party of, based on your income that you provided and based on your income that you provided, here's what the Child Support Standards Act figure would be for child support. And then the parties can decide right then and there that they're okay with that amount and enter into an agreement. Or they can ask for a hearing because there may be some factors, like I talked about, that would warrant deviating upwards or downwards from the Child Support Standards Act figure. So the judge would then set it down for a hearing, and then we would meet with you multiple times to prepare for it. And at the end of the hearing, at the end of all the court appearances, the support magistrate would issue an order ordering the non-custodial parent to pay a certain amount as child support to the custodial parent. To contact us, or if you have any other questions, you can go to our website. It's www.jacksonbergman.com. There's a place on the website where you can fill out a questionnaire, and it gets sent right to one of the attorneys in the office here. And then we will contact you, and we'll set up an initial consultation with you, which is free. You'd come in and meet with either me or Ben or Tom, and we would get familiar with your case, the facts and circumstances, answer any questions that you have, and give you an idea of how we think you should go forward and how we can help you out.